In the tax context, a discharge of indebtedness may reduce a person's tax obligations. It typically means a debt was canceled. If a debt was forgiven in exchange for surrendering collateral, is that also a discharge of indebtedness? Or is that a payment of indebtedness? We explore these questions in Gehls versus Commissioner. Laura and James Gehl mortgaged their family farm using a recourse loan. The Gehls encountered financial difficulties, became insolvent, and defaulted on the mortgage, which had a balance of around $150,000. Because this was a mortgage, the lender could take the entire farm to repay the debt. Because this was a recourse loan, the lender could go after the Gehls personally for any remaining debt not covered by the farm's value. However, the Gehls negotiated a deal. They voluntarily transferred $120,000 worth of farmland to the lender. In exchange, the lender let the Gehls keep a small portion of the farm and wrote off the remaining approximately $30,000 of mortgage debt. The Gehls were audited. The Commissioner of Internal Revenue determined that the $30,000 write-off was a discharge of indebtedness that occurred while the Gehls were insolvent. Under Internal Revenue Code's insolvency exception, found in Section 108A, the Gehls' gain from this discharge wasn't taxable. However, the Commissioner determined that the land transfer transaction was a type of sale, not a discharge of indebtedness. The Gehls' tax basis in the transferred land was around $50,000, so the Gehls had gained around $70,000 in value from the transfer. Because this was a gain from a sale, it was taxable, and the Gehls owed an additional $20,000 in income tax. The Gehls petitioned the United States Tax Court, arguing that the $70,000 gain was from a discharge of indebtedness and not taxable. The tax court ruled that the land transfer gain was taxable. The Gehls appealed to the Eighth Circuit.